Mr. Chairman, thank you. Thank you all for your continued service. I want to be able to follow up on a conversation, Commissioner Danley, that you brought up earlier about the environmental impact statements versus the environmental assessments. This has been a question from multiple different individuals and groups within my state on trying to be able to figure out the certainty of where things are going on that. Is there something you need to be able to finish out in that statement? You raised that earlier on that.
No, I think I made my point from before. I'm merely concerned that in some perhaps misbegotten desire to ensure that our orders are legally durable unnecessarily, because basically I think that we have been able to deal with most of the alleged legal infirmities that have been raised by my colleagues on our EAs and EIS, or our EAs specifically, as we have for years, and have withstood every challenge in court by addressing those comments in the order, right? The record of decision, which is the consummation of the NEPA process in the case of FERC, is actually the initial order that we issue. And I don't think that it's necessary to go through the process of producing EISs that come to the same conclusion that the EA did.
Right.
We can handle those comments.
Chairman Glick, this is an ongoing issue as well, just the predictability of the process so that people, when they're planning capital, know that they're actually going to be able to do investment at a time based on what they already received. How do you balance that out?
Absolutely, and I think you hit on the key word, certainty. The court has been, the D.C. Circuit has admonished the Commission on 3 separate occasions just with regard to our examination of greenhouse gas emissions. We actually didn't review those emissions. We didn't review the significance of those emissions. And the court said all 3 times, we're sending the case back to FERC. It causes extra delay. We've seen that in a bunch of other cases. You look at the Atlantic Coast Pipeline is probably the poster child for this. And this is a different agency, the Interior Department. It got it wrong in the previous administration. The court sent it back, added several years and extra billions of dollars onto the process.
So with that, are you assuming that all orders in the future are going to be EIS statements? There won't be EAs at all?
No, I think we still go forward with some EAs, but if there's any question as to whether there is significance of greenhouse gas emissions, the law requires us to do an environmental impact statement instead of an EA.
So you think that's going to be closer to the default then?
No, I think what we're going to do, hopefully pursuant to this notice of inquiry process that's been initiated, is set up a particular standard below which a certain number of emissions, and I don't know what that is, obviously all the commissioners have to agree on that, below which I think projects can go forward with environmental assessments, above which they're significant, and then we're going to need to consider other issues pursuant to an environmental impact statement.
How will you handle social cost of carbon scoring, or will that fit into this?
Well, we're waiting for guidance from the CEQ on that, but the court in the Vecinos case that was just issued recently suggested the commission needed to at least take a look at the social cost of carbon as whether, in terms of assessing whether the greenhouse gas emissions.
Clearly, when you get into social cost of carbon, you get into lots of different models from lots of different places. People that typically write the models for social cost of carbon have a certain view as well of what they're taking into account on that. As an independent body, how are you going to be able to manage what is the right scoring for social cost of carbon?
Well, there is a level of uncertainty, and the Vecinos court pointed that out recently, but we do actually have to take that into account, and we're waiting for guidance again from CEQ, but as an independent agency, we're going to have to make our own judgment pursuant to a majority vote of the commission.
So this is not an assumption that this is going to come down from the administration and hand you, here's the way to be able to handle social cost of carbon?
Now, the commission has historically tried to follow CEQ guidance on NEPA reviews as much as we can, but no, we have to make our own determination.
So, Chairman Glick, let me just stick with you this. FERC trying to be able to issue the revised pipeline certification policy statement. There's been some conversation about this. When do you think that comes down?
We're reviewing. We received a large number of comments. We're reviewing it. I was disappointed. You know, we started this process back under Chairman McIntyre several years ago, and the commission never moved it forward. So we're trying to move it forward now as quickly as we can. I'm hoping within months, but don't have an exact timetable for you just yet.
Okay, thank you. Mr. Christie, I want to be able to drill down on something on the issue about large transmission lines. Obviously, you've dealt with this a lot. I've brought up multiple times the Transwest transmission line. There's lots of other ancillary issues there, but they've been 14 years in process just to do the permit, and they've not put up a tower yet. There's been a lot of push on having us at 100% renewable in the generation field by 2035, 14 years away from that. Is that a realistic time period just based on the permitting process to be able to transmit power from long distances and intermittent sources?
Well, the problem, Senator, is this with these long-distance transmission lines that go over multiple states. And I've sat on many transmission line cases and actually voted for the longest transmission line in PJM today, the trail line, Trans-Allegheny. The fact is, when you cross 5 or 6 states with 300 or 400 miles of a 765 kV line, they're going to have tremendous opposition. That's just political reality. And so you're not going to get many of those permitted, and it's not because of any conspiracy. It's just the political reality that people don't want. You're going to have a tremendous political backlash. It's very hard to get these interstate lines sited. The important thing about transmission is this. If a transmission line is needed, then it ought to be built. If it's needed to serve reliability, then it ought to be built. And I think, frankly, the people in each state are willing to accept transmission lines. There are going to be controversial, I can tell you. I've sat in high school gyms and been yelled at by people that didn't want to look at a transmission line. But people will accept if they think that their state regulators have done right by them, had a good record. But I think, though, that politically, if you try to run a line across 6 states, I think that it's going to be much harder politically to get those cited, and people are not going to really accept the fact that a line like that is needed, particularly if it's only going to benefit a special interest group.
Great. Thanks. We'll follow up with questions for the record. Thank you.